On June 27th will be the first hearing for the second case at the Khmer Rouge Tribunal, which is a United Nations-backed hybrid court in Phnom Penh adjudicating some of the atrocities of the Khmer Rouge regime. And this case is particularly important because it's a joint trial of 4 senior leaders who were cabinet-level officials in the Pol Pot regime. The first case, which finished last year and which is now on appeal, featured Doik, who was the head of the chief torture and interrogation facility in Phnom Penh. It was an important case, but many of the facts about Doik's activities were already well known because there was ample documentary information. The second case is particularly important, both because of the senior stature of the defendants and because there's a little bit less historical information about how they operated at the senior-most levels of the regime. And so both from the standpoint of justice and also truth-telling, this is by many people seen as the most important case that will come before the court. Now, the legal definition of genocide under the 1948 Convention is quite narrow and covers crimes directed at racial, ethnic, national, or religious groups. And in the Cambodian case, what's unique about the Pol Pot reign of terror is that most of the victims were part of the majority population of ethnic Khmer Buddhists. And so it's been a legal conundrum on how exactly to characterize these crimes. In the second case, the 4 defendants who will be jointly tried will face charges of genocide with respect to 2 particular minority groups, Cham Muslims and ethnic Vietnamese. But most of the offenses that they're charged for will come under the categories of crimes against humanity or war crimes. There was some concern that the label of genocide would have great importance to the public in Cambodia, that victims would feel aggrieved if the crimes committed against them were not categorized as genocide, which is popularly associated with being the crime of crimes. But in fact, it seems that the public has been more concerned with the general perception that justice is being done, and that hasn't been as much of an issue at the popular level. One of the advantages of a hybrid court that's located in the country where the atrocities were committed, like the Khmer Rouge Tribunal, is that it's close to the scene of the crime, and victims, at least in theory, should have a better opportunity to participate in the tribunal. And in this case, victims can come to the proceedings and watch it live in person, although of course the numbers are limited. They can also go to village forums run by NGOs, and there are official ways that they can get involved in the proceedings by serving as witnesses, by filing complaints, or by joining as civil parties. Unlike common law courts, the Cambodian tribunal, which is based on the civil law model, allows civil parties to join the criminal proceedings and be represented by lawyers in the courtroom, and to seek, in this case, collective and moral reparations as opposed to financial ones. Now, in the first case against Doik, the civil party scheme, which is very innovative, had clear advantages, so that civil parties got up and spoke and were heard and represented the class of victims. On the other hand, it became somewhat unwieldy because there are a large number of victims. It's difficult to incorporate them in an efficient court process. And so in the second trial, one of the keys to success will be whether the court can make the civil party process more efficient without sacrificing the voice of the victims. Recently, a number of people who were working with one of the investigating judges resigned from the court, alleging that the court had become tainted by political interference and arguing that they were unable to do their jobs properly because of political meddling in the tribunal's operations. Certainly, for many observers, this will have a detrimental impact on the credibility of the court. In fact, it could have a crippling effect on the legitimacy of the court from many perspectives. Going forward, what the court needs to do most in order to restore some of its credibility is to handle the second case effectively, which is indeed the most important case that will come before the tribunal against the 4 senior members of the Khmer Rouge regime.